And the first thing I want to do is I want to thank colleagues who have spoken and contributed to the debate. And it is notable that everyone who spoke and every political party represented in this House, indeed every independent, is supportive of this legislation. And just from the French family point of view, that is unusual. And I suppose the reason why there is such support of it is significantly because the memory of Valerie French and the campaigning of David and his sisters is something that's at the forefront of the minds of legislators when we're considering this issue. It's generally the case, I have to say, when you have a human story behind a piece of legislation, or when somebody is prepared to advocate from a very personal point of view, it can have a very significant impact on the houses of the Oireachtas, and that certainly has happened in the case of Valerie French and the campaign that was put forward by David and her sisters. Can I just deal briefly with some of the points that were raised by colleagues, and there were some very worthwhile points made that I would like to reply to. First of all, I welcome Deputy Devine and Sinn Féin's welcome of the legislation. Deputy Devine referred to the Oireachtas Justice Committee. I should have said at the outset that I want to thank the Oireachtas Justice Committee for the work they did and the recommendations they made. Very many of those recommendations have been implemented, and all of them were considered by me. One of the points that was raised by Deputy Devine was that she questioned whether or not a family member should be permitted to bring the application, as well as Tusla being able to do so. I think that would be unwise, because I think it would put a lot of pressure on family members, and there could be disputes within families as to whether or not such applications should be made. The legislation as is drafted at present means that Tusla must bring an application. So in many respects, Tusla's function is to get the issue before the district court, and it is then the court that will determine the matter. So there is a logic, I think, to have a mandatory requirement imposed on a statutory body to bring the issue of removal or restriction of guardianship rights before the district court. One of the issues that Deputy Devine also mentioned was, should there be a specialist unit within Tusla? Fortunately, these applications will not be very large in number. They will still be very significant and very important, but it will be the case, I think, that the resourcing within Tusla will be well able to deal with it. One of the issues Deputy Devine also raised was whether or not there should be a special exemption in the legislation, say for somebody who was convicted of manslaughter, but it was manslaughter because it was self-defence because they'd been subjected to domestic abuse. That was a point that was also raised by Deputy Kelly. I suppose the reason why there is no mandatory requirement on the court to remove the guardianship rights is because there's a recognition that circumstances in these cases will differ. And as everyone has said, we need to hear the voice of the child as well in terms of these applications. So obviously, if there was a situation that arose, such as suggested by Deputy Devine, that would be given consideration by the district court. Deputy Kelly also made some issues about 12D. I'll have a look at that. He raised the issues of Tusla, and he talked about the constitutionality of the legislation. I have to say, had there been a mandatory requirement in this legislation that said if somebody is convicted of murder or manslaughter, that they automatically lose guardianship rights, I think that would have been constitutionally questionable. That's why it was so important to give a discretionary power to the court, so that the court could take into consideration all of the individual circumstances. Deputy Kelly also raised the issue about a register of guardians. That is a recommendation which was given serious consideration, and I'm not trying to disown the necessity for it, it is something that's beyond the responsibility of this bill, and it is something that would require a considerable body of work as well. One of the other issues that Deputy Kelly raised was in terms of the timing of it. Under the legislation, an application must be made within 6 months of conviction. And obviously that is going to take a period of time. There's going to be a period of time from the date of the murder or manslaughter until a person is convicted. But in truth, what happens on an immediate basis is, if there is a terrible event that happens, a murder or a manslaughter, measures are put in place immediately in order to put a childcare plan in place for the children. And obviously the guardianship issue can be dealt with at a later stage, but there's an immediate requirement literally to find out who's going to care for these children tonight or for the next number of weeks. And that is an issue where the Child Care Act already operates. Deputy Farrelly also made points in respect of the Children's Ombudsman and Tusla. There was criticism of Tusla by a number of deputies. Can I just say I don't think there is a statutory agency in the state that has a more difficult task than Tusla. And it is also important to point out that, abuse of children and the need for the state to intervene, happens not just within area where the state has responsibility for children, but it happens within families as well. I thank Deputy Devlin for his contribution. Obviously, guardianship is about making decisions as to how a child should be brought up. In many ways, it's different to accessing custody. Custody is about with whom or where a child should be brought up. But guardianship really relates to some of the most fundamental decisions that are made or to be made about a child. Deputy Gorman also recognised that there needed to be a change here. He spoke about their consideration being given to an interim order. As I said a few moments ago, it's certainly the case once a terrible event happens, if a guardian kills another guardian, and in advance of the determination of criminal liability, measures will have to be put in place immediately from that night onwards, and that sometimes happens as a result of applications made under the Child Care Acts. That is what happened. I'll get back to Deputy Gorman in respect of the report he mentioned about guardianship. Deputy Butterley also spoke about recognising that it is, in effect, a form of child abuse for one parent to kill another parent. Like, that has an extraordinarily damaging impact on the children left behind. And that's why I keep emphasising that this legislation, it's not about imposing a further punishment on a person who's been convicted of murder or manslaughter, but it's about ensuring that the best interests of the child are protected. Deputy Nolan, I think, is in favour of the legislation, but she was very critical of Tusla and made some allegations in respect of events happening to young girls in the area. Obviously, if anyone has any information on this, it needs to be brought to the attention of An Garda Síochána. But I do think that Tusla is the appropriate statutory body to bring this application before the district court. Like, the alternative was to go out of our way to set up a new statutory agency that would simply have responsibility for this, and I don't think that was feasible. And Deputy Cronin also was happy to support the bill. She spoke about femicide. We do have a problem throughout the world in respect to femicide, but we have to confront the problems that this legislature is responsible for in Ireland. And regrettably, it is the case that violence against women is a problem that needs to be confronted and responded to, not just through legislation, but also through education and information, and I suppose ensuring that domestic violence is recognised as the scourge it is and isn't tolerated. Deputy Coppinger spoke about violence within homes, and she spoke about feminicide as well, and referred to Northern Ireland. It is the case that Northern Ireland is the most violent place in the United Kingdom for a woman. And if you look at the statistics in respect of the killing of women in Northern Ireland, they're significantly more than they are here in Ireland, and they're significantly more than Scotland, Wales and England. There's obviously a reason for that. And, we need to do research into this, because we're never going to be able to resolve this problem by simply punishing people after the terrible events occur. We need to investigate and research why it is that men, and predominantly it is men, engage in violence against women, and that's something that I think requires further research, and we shouldn't shy away from. Deputy Coppinger also mentioned issues about the miscellaneous provisions bill, but we have an opportunity to discuss that even further when we're back here for report stage. Thank you very much, Ken Corner.
Thank you for watching. Please like and share.